Advocate Mkugai Toby. Thank you. This is the one I need. I don't need these ones. Let me just ensure our record is here. Okay. Then the court is ready to proceed with sentence in the matter of Julius Malema, hereinafter referred to as the accused. Mr. Malema, please be seated for the duration of the sentence. As judgment, the court can leave no stone unturned, so we'll arrive and I will tell you when to stand up. Thank you. Just as courtesy then, for the state appears Advocate Caesar and the defense being Advocate Odes and Advocate Mkugai Toby as instructed by Ian Levitt attorneys. The others were mentioned and acknowledged on record yesterday. And as stated, the court will proceed with sentence. The accused before court was convicted of 5 counts. Count 1, contravening Section 3 of Act 60 of 2000 of the Firearms Control Act, read with the provisions of Section 1, 103, 117, 120, in brackets 1A and 121, read with Column 1 of Schedule 4 of the said Act, being the unlawful possession of a firearm. Count 2, contravening Section 90 of the Firearms Control Act 60 of 2000, read with the same provisions mentioned in Count 1, being the unlawful possession of ammunition. Count 3, contravening Section 120, subsection 7 of the Firearm Controls Act 60 of 2000, being the unlawful discharge of a firearm in a built-up area. Count 4, contravening Section 120, subsection 3C of the Firearms Control Act 60 of 2000, being the unlawful failure to take reasonable precautions to avoid danger to a person or property in circumstances where it created a risk to the safety or property of the general public. Count 5, contravening Section 120, subsection 3B of the Firearms Control Act 60 of 2000, reckless endangerment to a person or property. The applicable penalty clauses as invoked by the state and in terms of Section 121 of the Firearms Control Act 60 of 2000, with specific reference to Column 1 and Schedule 4 of the said Act. For record purposes, the court will place them on record. In respect of Count 1, it is a maximum of 15 years imprisonment. In respect of Count 2, a maximum of 15 years imprisonment. In respect of Count 3, a maximum term of 5 years imprisonment. In respect of Count 4, a maximum term of 5 years imprisonment. In respect of Count 5, a maximum term of 5 years imprisonment. In essence, the various sections invoked by the state, as read with each count, means the following. I deem it necessary to state all this 103s. I'll give a brief explanation. Section 103 of the Firearms Control Act 60 of 2000 deals with the crimes and offences giving rise to unfitness inquiries by courts after conviction or sentence of any of the offences as mentioned. Section 121 of the Firearms Control Act states that any person convicted of contravening any of the sections mentioned in Column 1 of Schedule 4 may be sentenced to a fine or to imprisonment for a period not should be exceeding the period mentioned in Column 2 of the said schedule. Section 120 of Act 60 of 2000, as invoked in each count, refers to the offences, penalties, and the administrative fines applicable. Section 151 of the Firearms Control Act 60 of 2000 states that despite any law to the contrary, Any magistrate's court has jurisdiction to impose any penalty provided for in terms of the said Act. The court deemed it fit to explain the relevant section invoked by the state in each count for clarity purposes only. It should be noted, and it is well known by this stage, that the provisions of Section 51, subsection 2 of the Criminal Law Amendment Act 105 of 1997 is not applicable in the matter before court, as the section was not invoked by the state in the charge sheet at the commencement of the trial. Therefore, the accused was not warned in terms of the above-mentioned section. It merely means that instead of a minimum sentence of 15 years applicable in respect of counts 1 and 2, the state invoked the penalty clause as contained in column 1 of Schedule 4 of the said Act, which prescribes a maximum penalty of 15 years imprisonment. I trust this explanation is understood and the reasons as to why the minimum sentence is not applicable, and that the defense does not need to show compelling or substantial circumstances for the court to warrant a deviation of the minimum sentence legislation. Plainly stated is one of semantics, the one dealing with a minimum of 15 years, the second with a maximum term of 15 years imprisonment. With regards to the maximum sentence, the normal principles followed by courts when sentence is considered is therefore applicable. The above charges relate to the incident relating to the EFF, or the Economic Freedom Fighters' 5th birthday celebration held at Sisa Dukashe Stadium, Mtansane, on the 28th of July 2018. The incident led to the arrest of the accused and his subsequent appearance in court on 27 November 2019. Thereafter, as a result of the COVID pandemic which the country faced, the accused appeared for the first time in person before this court, and you'll need to bear with me here, on the 29th of March 2021, on which date a trial date was then secured. The trial date for the matter to proceed was 27 August 2021. However, the erstwhile state advocate was ill, and she had notified parties beforehand that the matter may not proceed, and a postponement for trial was arranged in the absence of the accused and the defense team, and the trial date then secured being 28 February 2022. On the said date, Advocate Caesar appeared on behalf of the state, and the case formally proceeded, or the trial proceeded, on 1 March 2022 for the week up to the 4th of March 2022, being for 4 days. From there it was postponed to 5 September 2022 for the week. However, and this is not criticism at all, because the matter was dealt with very professionally, as the defense had indicated a prior commitment and could not honor the week of September, and in the absence of all parties, a date for further evidence was then arranged, being 30 January up to the 3rd of February 2023, and it proceeded for 5 consecutive days. 1 September 2023 was the following dates up to 14 September 2023, that was 4 days, and the state case was closed on the 14th of September, meaning it was a total of 13 court days that was spent on the state's case after hearing plus minus 19 state witnesses and 3 applications brought by the defense in that period. I would say 2 because the 174 I'll deal with now. As from the 14th of September, the matter was postponed to the 20th of September 2023, whereby a Section 174 application was brought by the defense, and the ruling by court on the 19th of October 2023 was then ruled in terms of Section 174, and that ended the state matter, the 3 applications, and it lasted a total of 15 court days. During the week of 18 June 2024 to 20 June 2024, after 3 consecutive days, the defense case was closed, And on 1 November 2024, the date was secured, including the date of 9 December 2024, was set aside for redress on merits. However, due to myself having sustained an injury, I indicated to the state and the defense that there's a possibility that I may not be present on the 1st of November, which I happen to be, and they had elected, correctly so, the safest option was to proceed on the 9th of December 2024 for redress on merits. Indeed, then it had proceeded on the 9th of December 2024, continued, where am I now? 2024. Thereafter, 29, yes, the defense case was then closed. It continued 29 September 2025, 30 September 2025, and 1 October 2025 for the extremely long judgment delivered by this court. I still shudder. Thereafter, it was postponed to 23 January 2026 for the pre-sentence report, which was then the court heard the evidence of Ms. Jessie Thompson, and from that date postponed to yesterday, 15 April, and I will summarize the proceedings that took place yesterday, and then hence we find ourselves here today, 16 April 2026. In total, I think what felt like an extremely long time and which has been discussed as 7.5 years, it's clear having to combine 6-7 defense counsel, state, court was available, nonetheless was quite a task, and it amounted to the matter proceeding plus minus twice a year on 4.5 days per session. So the trial lasted, I would say, plus minus 31 days. Okay. Let me just see where I stopped. The court has decided to, in this instance, instead of starting by placing on record the provisions or principles traditionally taken into account by any sentencing court, to deal with the mitigating heads of argument placed on record by the defense, thereafter with the address by the state, and then the court will proceed in calmness with the principles applicable before sentence. Okay. First then, with regards to the heads of the defense, and the same will apply to the state, the court does not deem it necessary to repeat what has been placed before court. The defense had submitted detailed written heads of argument in advance and then addressed the court yesterday, being the 15th of April 2026. Therefore, the court has indeed had sufficient time prior to yesterday to read, peruse, and after yesterday's arguments to digest what has been presented to court by the defense. I will start off by, it goes without saying that in this instance, the defense had requested that or stated that there is no other sentence which is appropriate save for a non-custodial sentence, and I will continue with that at a later stage. Therefore, the court has had the opportunity to visit and peruse all the case law as quoted in great detail by the defense and has given it the full attention that it deserves. The case law is attached, although in 3 pages, to the heads of argument filed by the defense. It will be a moot exercise to repeat all the cases listed, unless you would require me to do so. The same may be said regarding the pre-sentence report. It was submitted to court on the 23rd of January 2026, and Ms. Thompson had read the report into the record verbatim. Therefore, there is no need to repeat the contents, as it is reflected and recorded and forms part of the written transcription and record of this court. The court therefore has had more than sufficient time to peruse and to take note of the contents of the said report, and combined with the evidence in chief, the cross-examination that followed, including the re-examination and clarity questions by court, it is clear that the pre-sentence report has been noted fully, and I will deal with the recommendations shortly. The contents are noted and accepted, therefore, as evidence on behalf of the accused person. The court will, however, refer to a few points that may require a response from court at a later stage. The court has indeed scrutinized the case law quoted by the defense in paragraphs 25, 26, and 27, and the court reiterates the importance of the findings made regarding the role of the courts in upholding the Constitution, wherein the state is described as the role model for our society. This court is in total agreement with the submissions that let me just open this file. This court is therefore in total agreement with the submissions by the defense that a court's impartiality must never be open to reasonable doubt. For its moral authority, without it, would cease to enjoy legitimate public confidence and ready compliance with its decisions by all, and that our courts are to defend and uphold the Constitution and the rights entrenched therein. More so when the deprivation of an individual's liberty or freedom may be affected. It is indeed a core right to be enjoyed by all. Paragraphs 28, 29, 30, 31, and 32 sets out all the examples of sentences imposed by our courts as stipulated in the heads of arguments. There is no need to repeat the paragraphs, it was read into the record. What is clear is that there are a variety of sentences imposed by our courts regarding the possession of firearms over the years, pertaining to semi-automatic rifles, pistols, revolvers, including offences that were committed using firearms. What is to be distinguished in these matters are notably, as raised by the defence and as per the pre-sentence report and viva voce evidence of Ms. Thompson, the circumstances under which the offences were committed, including the purpose therefore thereof, the duration, and as highlighted by the defense, the issue whether any harm or injuries emanated from the offences. Further, that the ammunition was fired had been described as celebratory shots, and that there is no case law pertaining to the facts relating to the matter before court, more so based on the term used being, and I quote, celebratory shots. A further submission by the defense on record mentions that should any court consider a custodial sentence as appropriate in the matter before the court, it will be seen as the accused is singled out for unduly harsh punishment. The defense concedes the offences are serious and that the case law differs as the defense had pointed out in the case law on record, and surely again emphasized that the duration, circumstances, including the lack of harm to person or property, should be considered, that indeed it is the accused's right not to show any remorse. It has no impact on sentence. Further, that the accused regrets the perception that his actions created, When dealing with the pre-sentence report, it may appear as if it is a repetition on the side of the court, but I need to mention, because the points raised by Ms. Thompson indeed overlaps with the heads of the defense drafted on behalf of the accused. In addition to the heads, I will add the following: that the accused person's personality type was assessed, and the reason for doing so was to offer context to his conduct and potential behavior expectations. Ms. Thompson had regard to the personal circumstances of the accused, his background, education and career. Further, that the accused continues to assert his innocence. Nevertheless, however, he regrets the incident. The report deals with the evaluation of actual and potential harm because of the offences, the seriousness of the offences, as well as, once again, the purpose of the offences. And in recommendations, Ms. Thompson proposed that a monetary fine as a sentence option should be applicable, and describes the fine as a sentence option which will reflect the gravity of the offence. Further suggestions by Ms. Thompson were to restrict the accused person from obtaining a firearm license for a specified period, and that he should be ordered to make a financial contribution to Gun Free South Africa, an NGO focusing on reducing gun violence in South Africa. She also testified, and it is contained in the said report, that the firing of the celebratory shots had been deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. She continues to state that the planning does not suggest that the activity was undertaken with the intent to commit an offence or endanger lives or cause damage to property. And as mentioned in paragraph 17.3 of the defense heads of argument now, that the careless and reckless discharge of firearms in a public setting conveys an inappropriate message about gun safety and responsible firearm use. Now, in this instance, it was mentioned that particularly when a prominent leader exhibits such conduct. The court agrees with this submission. Further, the court agrees with the submission by the defense that the actions of individuals in positions of influence are likely to be emulated by their supporters, thereby warranting what is perceived to be more severe assessment of their behavior. However, the defense then proceeded to state that the behavior of the accused indeed once again reiterated did not cause harm to person property, and the court was then requested to consider that the said firearm in question was returned to the lawful custodian promptly, and that the celebratory shots were fired in a very short space of time, and that the accused had not loaded the ammunition personally. Further, that the accused had obtained the firearm from an individual most likely affiliated with tactical security services. On this aspect, and on certain aspects raised by counsel yesterday, it's clear this aspect was dealt with in judgment. It refers to the merits, and when we deal with leave to appeal application, it is when the court will hear the merits. The court's finding in judgment is clearly stipulated regarding how possession, there was no finding as to how possession was gained. That is as far as I'm going to say. The rest we'll do during leave to appeal. And some of the controversial statements during, how will I say, reply by replying counsel. That in essence were the points raised by the defense and the social worker, Ms. Thompson. And as I've stated yesterday, reading the paper gives new meaning when one hears the oral arguments in court. It gives more perspective, insight, to see and hear the tone of how a statement is made has a different impact on a court as a piece of paper which is words. So therefore it was important for the court yesterday to pause when it did and then retire to indeed consider sentence. Those were the aspects as stated, dealt with by the defense, and I will now deal with the aggravating circumstances as indicated or raised by Advocate Caesar on behalf of the state. The state submitted that they request that the court should consider a custodial sentence in this matter for the following reasons: that the incident was planned and it was deliberate and executed with precision, and that the submission is made based on the accused's own evidence. Also on this aspect, I would say we will deal with the merits once we reach that point. Further, that it was a collective decision made by the EFF's leadership and that it was planned to entertain the crowd to ensure that the crowd is not bored during the event. In this regard, the state relies on the submissions based on the evidence of the accused that, I quote, everything was perfect and calculated and designed to be the way it was done, unquote. Therefore, it was not an act based on a lapse of judgment. These submissions was then substantiated based on the case law by the defense and similarly quoted then by the state. The state and the defense basically in fact relied on the same case law pertaining to this matter. The state continued to submit that on the ballistic evidence presented, it was established that to discharge a semi-automatic rifle in a built-up area densely populated using a .223 Remington round was fired, and that retains lethal kinetic energy on descent. The potential for mass injury or harm was real, it was foreseeable and scientifically established. Mtansane is a residential area. The state alluded to the fact that the accused position as a public leader and role model is, I would say, a fact. Submissions made thereafter by the state requested the court to consider that the accused is a member of parliament and also the president of a political party, admired and followed by millions of South African citizens, and arguing that it is aggravating and not mitigating as per the defense submissions in this regard. The state referred to the video footage which was accepted by court. That again, I will say, deals with the merits. It was clear what footage was admitted by court and what was not admitted. The state alleged that the accused clearly lacked insight and accountability and sought political justification as an excuse, thereby undermining the public confidence in the administration of justice. These submissions was followed by the concerns the state raised regarding the evidence and pre-sentence report drafted by Ms. Thompson and the findings by the witness and the submissions by the defense regarding the brevity of the possession and that it was not accidental, and that the discharge of a semi-automatic rifle cannot be described as benign, and since the risk of injury or harm is extreme. Celebratory purposes in this regard, the state submitted that this type may not be condoned, this type of discharge may not be condoned, and that the law makes no provision for such actions. The state then embarked on the discussion and submissions regarding the case law, which was placed on record. I am not going to repeat, it has been noted. The only difference I may add by the side is that although the state and the defense relied on the same case law, it is clear that the state will use the portions which is beneficial to them, and the defense would obviously use the portions which is beneficial to the defense. And ultimately, at the end, the court is required to bring them together. The fact that the state further continued that the fact that there appears to be no harm or injury caused as a result of the commission of the offence is conceded by the state, however disagrees with the defence regarding the weight that it should be attached by court. The Parliament criminalised the creation of risk, not that there is a requirement of an actual harm or injury, but the actual act itself. The state continued to highlight three, which they termed, I'll say, pointers, that being the imperative of equality before the law. I'm not going to elaborate on that point at this stage. The imperative of proportionality and the imperative of deterrence. Those were the three highlighted by the state. And concluded its submissions by referring to State v. Zinn and pressing I'm trying to also expedite the sentence, just a minute. The state then submitted that the proposed sentences will give proper effect to all the principles and objectives set out in State v. Zinn with safety, and it will satisfy the constitutional mandate of equal treatment before the law, and it will serve the legitimate and pressing interests of a society that has the right to expect its leaders to obey the same laws they are elected to uphold. Now, the court will proceed with the principles traditionally taken into account by sentencing court. It is a well-known fact that sentence proceedings are the most difficult part of any court proceedings. It does not only affect the accused person, but also the family of the offender, including the society, that being the public welfare, safety concern, and the interest of society. It is also known that a court is obliged to consider the normal aspects of sentence traditionally taken into account before imposing sentence. These aspects being the accused is indeed a first offender before court and has no outstanding or pending criminal matters. It also includes the possibility of reoffending. I'm not going to elaborate on that aspect. It was done by the defense. It is noted as one of the principles to be taken into account. It also includes loss of employment. In this instance, the case law is clear that should sentence result in the loss of employment, it should be noted that crime is an inevitable consequence of crime, or loss of employment is an inevitable consequence of crime. The court is also obliged to consider the family of the offender. This fact was fully discussed in the pre-sentence report submitted by Ms. Thompson, who testified in mitigation of sentence. On this score, I also think it is appropriate to highlight, I do not intend to discuss the depth of the pre-sentence report, as was submitted by the defense in the heads yesterday, orally. that I accept it was an invasion of the accused's personal space. It could never be seen as an easy exercise. And we heard that evidence of Ms. Thompson, I think, in excess of 5 hours on the 23rd of January. And I think that in itself was surely not a pleasant experience. So I'm merely going to highlight how I have highlighted the content and then the family, etc. I do not intend to rehash personal circumstances which has been dealt with or heard. The other aspect that the court needs to consider is the state of health of the offender, and the court was informed that the accused does not suffer of any medical or physical ailments as per the report. Youthfulness, it is so that the accused is still relatively young. And most importantly, the position of trust. This is one pointer that the court will return to. It requires full reasoning by court, and I will do so during the process of sentencing. The further aspect is that the prevalence and seriousness of the offence. This is an aspect the court cannot shy away from today, but also requires full reasoning, and the court will do so during the proceeding of the sentence. Those two aspects. The above are but a few pointers traditionally taken into account by courts before sentence, and some require a detailed explanation by courts. It is well known that the ends of justice are four in number, being deterring, preventative, reformative, and retributive in its nature. It, however, consists of 5 important functions. It should act as a general deterrent. It should also act as a specific deterrent. It should also, or it must enable the possibility of correction. And it must be protective of society. And it must further also serve society's desire that crime be adequately addressed by courts. It is in the public interest that punishment be meted out fairly and without the measure of excessiveness that would mark it as being merciless and unacceptably unfair. The court is mindful that neither the call for true punishment and revenge, neither the cry for understanding must be given undue weight. The ends of justice, as mentioned already, must be given due regard when determining sentence. And it is required that a court should strive to accomplish and arrive at a judicious counterbalance between the elements mentioned and ensure that one element is not unduly accentuated at the expense or exclusion of any other element. It has been often stated in various case law that the sentence imposed should fit the offender as well as the crime. It must be fair to society and blended with a measure of mercy according to the circumstances of each matter. True mercy, therefore, has nothing in common with soft weakness or maudlin sympathy with the offender, since it is a crucial element of our justice system in its own right. It is also not an element that mere lip service is paid to, but indeed a sound factor that each court must consider and which must clearly reflect in the sentence imposed. However, courts are required not to strive as stated for severity, but neither on the other hand surrender to misplaced pity, and should not flinch from firmness where it is called for, and that a court should be strict enough to ensure that the objects of punishment are adequately furthered, and indicating thereby that crime will be effectively punished. Having said that, this court is well aware that a court should approach its task with a humane understanding of human behavior and frailties. Just a minute. I've been talking a lot, just a minute. I think at this stage, while we are still proceeding calmly, I'm going to deal with general concerns when reaching sentence regarding matters of this nature. Thereafter, the court will deal with the reply to the offence before court or the matter before court. It should be noted that crime is inconsistent with the rule of law and the fundamental value of our Constitution. It undermines the constitutional commitment to human dignity and further the achievement of equality, including the advancement of human rights and freedom. Crime is therefore the antithesis of an open, accountable, democratic government as required by our Constitution. Chaskelson P. in South African Association of Personal Injury Lawyers versus Heath and others, 2001, SA 1883, Constitutional Court, 2001, in brackets 1, states that, I quote, elected office bearers and officials in the public service have become one of the most serious threats to our country's well-being, and that is to state the obvious. Although the mentioned case deals with corruption and crimes of dishonesty, it is still relevant to the crime in general, and as far as it relates to public office bearers, as the impact and consequence pertaining to the matter before court today remains the same, if not worse. It is clear that if crimes are allowed to go unchecked and unpunished, it poses a serious threat to our democratic state. Crime in South Africa is ever escalating, and it appears to be an acceptable way of life in our country, this being a situation the courts cannot allow or tolerate. The incidents may well be characterized as a pandemic that needs to be recognized as such and requires concerted and drastic efforts to combat it. It is regrettable that too often in South African courts, the so-called, and I quote, non-violent crimes have been visited with lenient sentences due to the classification of no violence, and that perpetrators of these offences are seen as not to be truly criminals or even prison material due to their ostensibly respectable careers and lifestyles. The above-mentioned case stated on record speaks about dishonesty. However, this court will dare to say that it does not merely refer to related offences such as fraud, etc., but it includes the dishonest character of an individual, indicating that such conduct entails gross breaches of trust. At the beginning of the sentence, the court mentioned the element of trust and that a court should consider before imposing a sentence, and based on the facts of the matter before court, including the circumstances in which the offences were committed, it shouts of the breach of trust and is of great concern to this court today. The accused is in a position of trust and elected as such by the members of society. the conduct of the accused and the effect of his actions and the impact of the conviction on the accused combined all reflects, contrary to what is expected from our Constitution, the complete absence of accountability and breach of trust by the accused person before court. Going to try and summarize the response to the defense submissions as follows. It must be noted, and the accused confirmed, that the event was planned. Emphasis on the word event was planned, and that it was a unique established tradition planning an event. Firstly, I stand corrected on this aspect, but what I should have clarified is the following, that this was, according to the knowledge of this court, the fifth birthday celebration was the first of its kind. I do not understand the wording of it was a well-established tradition. We heard that the 10th birthday celebration, what the main feature was, but whether it was an established tradition at the 5th birthday celebration, I'm not aware. As a result, it is a great concern to this court that an event was planned and that what appears to be the unique feature of the event ended up in the commission of an offense or offenses. Surely this can never ring true. As per the submissions, the court is asked to consider that the accused had planned the event, and then it goes a step further, because contrary to the view of the defense and the view of the state, today it is clear that the planning included that the accused will possess or take possession of a semi-automatic rifle, fire a .223 Remington bullet into the air, thereby causing possible harm to person or property in a built-up area. That it is now called a celebratory shots, that is sugarcoating. Nothing more, nothing less. The facts found by court during its judgment, and this is not merits, these are facts. I'm going from memory. It was the evidence considered was that the accused had decided that the event was planned by the leadership. All decisions were made by the leadership. So there can be no doubt that you are saying the unique feature of the event was committing 5 offenses. That is the bottom line. Clearly, planning of this nature is in contrast with the law. How can a court of law consider that the actions of the accused did not intend or did not entail the intention to commit an offense? it is not it is not the thinking of the court, it is the facts before court, because that is what happened. It wasn't, as the state correctly stated, an impulsive act. It wasn't, as a result of the case law we heard, an act of passion. It wasn't anger. It was the event of the evening. And therein lies the difference. It should take considerable planning for an event of that magnitude, and I'm deviating from my written judgment, of that magnitude, that as to how, when, and exactly at what time you will take possession of the firearm, where you will fire it from, at which point we all know then, Mr. Snyman, you returned the firearm to Mr. Snyman. That finding was made by court. The court did not find it was handed to you by Mr. Snyman. That is what I'll say in that regard. So that to reason any otherwise is nonsensical. This is a decision that a person made to possess a semi-automatic rifle unlawfully, and including the decision then to proceed and fire the said rifle in a built-up area in a crowded stadium. The decision to break the law has been made, and it was made with the approval of the accused person and the leadership. Since it's confirmed that this was the future planned for the event, it clearly indicates that the accused had known it was unlawful. He knew that it may cause harm to persons or property. He knew all the above, and it yet proceeded to possess the rifle and to fire the shot in celebration of the 5th birthday celebrations of the economic freedom fighters. Always knowing when this was being planned, arranging this special feature that it is in contravention of the law. And that this decision was made long before the actual event. Such acts can never be condoned by this court in any instance. The court cannot dismiss these actions planned by the accused as mere celebratory shots, and further justify the commission of crime under the pretense that it was celebratory shots. Much has been said yesterday regarding other offenders who've committed acts of this nature, worse, who have has not been brought before a court of law. This court is not in a position to answer for those matters. Safe to say, I trust that surely the long arm of the law would reach and bring those offenders or suspected offenders before court. This court can only reply and answer for the matter before it, not for what has been said was done by Mr. A to Z or Miss A to Z. I'm unable to do so. My focus is on this matter solely. With regards to as I say, as far as it pertains to individuals who had committed the same offences and had not yet been brought before a court of law, should this type of reasoning be condoned, it is clearly not conducive to the interest of society, and the courts are required to act accordingly. And that is as much as I can say regarding the offenders who are still to be brought before courts. The other aspect that is aggravating in this matter and which needs to be mentioned is the astronomical financial impact this matter has had on the taxpayers' pockets or at the taxpayers' expenses. By saying that, please, that is not laid at the foot of the accused person solely, not at all. It was your right to take this matter on trial. I'm saying merely that a trial of this magnitude involved tremendous human or manpower. If we look at the ballistic side of this matter alone, the transport of firearms from KZN to Quebeca and back, the ballistic unit resources and equipment, preparation, SAPs. The tragedy is that this matter has also led to so many people that did not have access to this court on several days where this matter proceeded. Mothers could not approach the court for maintenance. They could not reach inside. Grandmothers could not come to the offices to apply for foster care or guardians, appointment, adoptions, domestic violence. Those people did not have access. And that is tragic. These are members of the community this court services on a daily basis. They wake up, as you very well know, all of us very well know, by 3 a.m., by 4 p.m., those little kids are dressed, washed, and they walk to court. And yet they cannot reach the entrance of this court for the help that they need. What has transpired is indeed sad. It's a sad day for justice if this is what bringing a matter of this nature to court results in the impact on the interest of society. And as I've stated, the courts must protect the interest of society. Not only did it affect those people I've mentioned, courts adjourned early. Our court rolls are overcrowded beyond comprehension. Inmates had to be returned to correctional services, leading to the extension of the overcrowding of prisons or correctional facilities. Witnesses who traveled from far, who lost a family member, let us say in a murder incident, they did not get closure on a specific day which was allocated to them for their matter to be heard. They have to come back. So yes, this matter indeed is sad because it has an immense tragic effect on the administration of justice and the very interest of society that is to be served by justice and its staff and courts. And that is not overemphasizing, that is a fact and a reality. The only aspect I'll mention with regards to the time frame of the actual possession of the rifle, yes, indeed, I agree it was very short. I agree with the submissions of the defense that yes, the charge sheet mentions 1.223 Remington cartridge, correct. I agree that the charge sheet mentions 1 SPA 249. Therefore, the court is limited to what you have been charged for, and that is what I'm dealing with. Nothing more. Safe to say then, on what the court has already alluded to, the commission of these offences are not insignificant, and the impact thereof remains the same, whether it was done in less than a minute. The impact remains the same. Now, this is a difficult matter to raise because it was alluded by the defense that should a custodial sentence be imposed by court, it will show that the accused is singled out to endure a harsh sentence. To this, the only reply from court is, it is not the court who has singled out the accused person. He had done so all by himself, not the court. In the light of the position that he holds as the CIC of a political party with massive support, it's not the court who had singled out the accused person. The fact remains there is a significant amount of accountability on the accused, and on this regard I'll add the following, that please remember, it is not a political party who has been convicted here. It is not the economic freedom fighters that have been convicted. It is a person, an individual, who so happens to be the CIC of a political party. Nothing more, nothing less. It's not the party. It's an individual, and that is how it is perceived. And while I'm on the topic which is uncomfortable for everyone, let us continue with this political trend that is followed. This court heard, as I've stated, plus minus 19 witnesses. Not a single witness testified before this court testified regarding any political facts, or that is not facts before court. The evidence or political agenda was raised by the accused, which is your right, but those are not facts as part of the state's case. And that's where it ends. A court of law and politics do not blend. The two do not collide. Judiciary stays in its lane. Politician stays in their lane. The easiest way to explain this is, I think the minds of a jurist and the minds of a politician do not function on the same frequency at all. Hence, a court is expected to remain independent, dispense with justice without fear, favor, or prejudice, and that is the duty of this court. The rest is of no interest, only the law. Just a minute. On this topic, I'll end off by saying, at all times, the judiciary, including the justice system, will never be intimidated by any politically charged utterances or parties. There is no room in a court of law dealing with a criminal offense for the court to enter into politics at all. just need to find my rhythm as well here. Right. What is apparent then is that people of this country are speaking as one. Crime is reaching astronomical proportions, and the courts are required to do all in its power to combat the situation and to ensure that all would-be offenders or offenders who are still to be brought before justice faces the full arm of justice. And surely if this is not done or goes unchecked, as I've stated, it will result in the perception that crime is an inevitable consequence of life in South Africa. It must further be noted, as much as the rights of the accused has been emphasized, and correctly so, as it is enshrined in our Constitution, members of society too enjoy rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all. I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Caesar. Just want to get to the relevant part. Yes. Okay. So gracious. The matter submitted by the state being Romeo Janssen and the state, case number CANR 220/18, delivered by D. Van Zyl, then DJP, and by the defense, that of the Malundana case, case number CC 20/2024, delivered by Brooks J. Now, in this instance, it was interesting to read both, and what is abundantly clear is that in the matter presented, the Malundana case, the facts are completely opposite as the ones we are dealing with today. In the matter submitted, the Malundana matter, was a gentleman of 62 years old who had, after a very long period of time, secured employment as a security officer protecting a school, which led to him firing a handmade firearm. The difference in that matter, which the judges considered as sentence and mitigation of sentence, is the accused there had pleaded guilty. He had also spent a period of time incarcerated, 4 months in custody before. Further, he was also a first offender. He had assisted the victims at the scene, and he himself had called the police to come and assist. He had also contributed to the costs of the family who suffered in the incident. That is the set of facts unique to that matter. Now, what is interesting in the Janssen matter, counsel argued yesterday that the matter cannot be of assistance to the court. I disagree on that aspect. Indeed it was, because I think it was said that he had previous convictions, Janssen. But when you read the actual judgment, the judge states clearly that the accused was treated as a first offender despite having previous convictions. So that is not relevant. That was, he said, and he was found to be or having been in possession only. There wasn't a crime that was committed on the day he was arrested with the firearm. And then interestingly, after being asked by the defense that all people be treated equal, it was submitted that Janssen is a gangster, therefore a member of Fat Boys, and therefore sentence of custodial sentence is in order. I failed to see the reasoning and the rationale behind that, but what is evident and clear after discussion of all the cases submitted by the state and the defense, in the view of this court, each case is unique. Every person is equal in law. What does equal mean in my view? That the court should ensure that accused rights to a fair trial is protected and that it applies equally to every individual who appears before a court of law. Sentences, we have this contradiction and variety because, as I've stated, each set of circumstances and facts are unique. If we take, without disrespecting a gangster, we cannot say for gangsters, right, there's a sentence of 5 years. For politicians, it should be 6 years. For the homeless person, it's 10 years. No. It's done in its totality. And unfortunately, the accountability on a public office bearer is a lot more. It weighs heavy than that of the regular South African person. So by saying that, that doesn't mean you are not treated equally or the accused is not treated equally. That is not what equality, in my view, entails. I'll end it shortly. There we go. Just a minute. I'm nearly done. Just a minute, please.
If I may, this is, I'm so sorry about this. I need an urgent comfort break. I've been sitting here since 7:30 this morning. So sorry about that.
I'm going to single you out, Advocate Caesar. So I was perusing the file to end off, but okay, can we then say, I'm sorry for this then, but instead of 5 minutes, it's a large crowd. Shall we say this is then the tea adjournment, we come back, we continue then thereafter? I'm sorry for this. No, Advocate Ingrid Obishai, I cannot, just now we all drown when that man cannot. Okay. Please, I'm going to, just a minute. Sorry, feel free to... I'm going to leave this. to come back and continue? Okay.